The next case is People versus Carter. This is a mini oral argument on the application. You each have 15 minutes. You may reserve, Mr. Baker, and you may not be interrupted for 3 minutes if you so choose.
May it please the court, for Alonzo Carter, I'm Douglas W. Baker of the State Appellate Defender Office. I would like to reserve the balance of my time if there is any balance for rebuttal, and I invite the court's questions at any point. I waive that free fire zone. With OV-12, the legislature intended that a sentencing court would look beyond the facts underlying the sentencing offense to other behavior for which the defendant had evaded conviction. In the words of the statute, the sentencing judge is to impose a score under OV-12 only when there is a contemporaneous felonious criminal act. And so, as this court, or as the Court of Appeals decided nearly a decade ago in People versus Light, the sentencing judge is to look beyond the sentencing offense and look to separate acts or behavior that did not establish the sentencing offense. This is not about determining whether you can relabel the sentencing facts, the offense facts, as some other kind of crime. In People versus Light was undoubtedly correctly decided. The legislature spoke of acts and not of crimes, spoke of acts and not of felonies. If it wanted to allow the court to look to the facts underlying the sentencing offense to figure out whether it could be described as some other kind of crime, it would not have used the word acts. It would have said contemporaneous felonies. As the court in Light recognized, it also distinguished between acts and the sentencing offense. And finally, as the court in Light also recognized, it also in OV-11 indicated that the judge, if the judge was not imposing points under OV-11 because the conduct at issue there did not occur during the same transaction as the criminal offense, could be scored under OV-12 if it extended beyond the sentencing offense. So it confirms this view that OV-12 is not about recategorizing the behavior underlying the sentencing offense as some other kind of crime, but instead looking for other conduct that the defendant committed for which he evaded prosecution.
How do you, in a case like this where one bullet would have been enough to sustain the offense that the defendant was convicted of, so they didn't have to talk about all three shots, does that separate this from a different kind of case where it's you couldn't have proved it with only part of what happened?
No, it doesn't separate it, but I would indicate that there are a number of other kinds of cases in which the same argument could be made. It's not simply something that's confined to gunshots. There are other assaultive offenses that rely upon a pattern of conduct that could be segregated into separate acts, stabbings, beatings, or combinations of different kinds of assaultive behavior. All could be segregated by a sentencing judge into this was enough to support the conviction. There is this rest of it that's left over that we could use to score OV-12. But that said, the prosecution making the argument that we can't tell the court with certainty what the jury thought about when they entered their conviction, and that's true, but I think that's the wrong question. The right question is, how do we know that they did not consider that information? That was the information that was presented to the jury. That was the body of evidence that they considered when making their verdict. And in fact, it would be a very strange set of affairs in which a jury were to have heard evidence of 3 gunshots and were to have decided we're going to base our conviction on gunshot 1 and not gunshots 2 and 3. Indeed, in this case, the prosecution, though, went beyond simply presenting the evidence to the jury and asking the jury to find in its favor. The prosecutor argued that the 3 gunshots were evidence of the defendant's state of mind, that you could derive something from looking at the 3 gunshots that wasn't there if there were just 1 gunshot. So,
I was about to ask a question, but didn't mean to interrupt you. I have a cold. But, so help me understand, stepping aside from the 3 shots, why the 3 different victims or potential victims doesn't support the scoring of OV-12 in this case. I realize it's the same 3 gunshots that were at issue, but isn't it a harder question when we have multiple potential victims?
Well, it's certainly a different question, but I think the answer is the same. The answer turns on what the legislature had in mind. What the legislature had in mind here was an inquiry in which the court looks, as I said before, beyond the facts underlying the sentencing offense to other conduct that the defendant may have engaged in for which the defendant was not going to be otherwise held accountable. In this case, the 3 gunshots were the body of evidence against him. The 3 gunshots that he fired trying to hit Mr. Sewell, that was the evidence supporting his conviction and sentence for which he was being punished. If it's conceivable, and I don't concede it, that the prosecution could have brought charges based on different victims, they could have done that, but that doesn't change that they didn't do it. And because they didn't do it, they cannot then point to that other offense because it's based on the sentencing behavior as a reason for scoring.
Couldn't the prosecutor say, well, I don't think the case against them, the other victims is that strong. I don't think I could prove it beyond a reasonable doubt, but I think I could prove it by a preponderance, and so use it for scoring. What's wrong with that thinking?
What's wrong with that is that's not what the legislature had in mind. What the legislature had in mind was looking at acts beyond the sentencing offense, looking at acts beyond what was needed to establish the sentencing offense.
And you get this from the language of the statute where it talks about what a contemporaneous felonious criminal act is?
Contemporaneous felonious criminal acts, I have a cold as well, Your Honor. Contemporaneous felonious criminal acts as opposed to felonies.
As opposed to what?
As opposed to felonies, as opposed to a crime. The court is supposed to be looking at whether the defendant engaged in conduct that was separate from the conduct involved in the case at issue. Conduct that supports conviction for some other offense and for which the defendant occurred within a 24-hour period and for which the defendant has not been and will not be convicted. Is it wrong to think of the sentencing offense as sort of the actus reus of the crime being the three shots in relation to your client? But then wouldn't we think of a different actus reus in relation to other potential victims, or would it be the same? I think it would, well.
In this case, I mean,
in this case,
lots of different facts.
As I understand the prosecution's theory, their theory is that not only could my client have been prosecuted and convicted for firing a gun with the intent to hit person A, Mr. Sewell, but he also could have been conceivably prosecuted and convicted for firing a gun towards person A, Mr. Sewell, and endangering person B, a baby on the inflatable mattress. That's a transferred intent theory. The problem with a transferred intent theory in this situation is that the transferred intent doctrine is normally intended for cases in which there is half a crime towards person A, there is intent to harm person A, but mistakenly person B is injured instead. And so 2 halves are combined to make a whole. But normally one crime is not made into 2 by virtue of the doctrine of transferred intent. That said, in some cases, and including one of the 2 cases that the prosecution refers to, Lovett, in some jurisdictions an exception has been made where person B is injured and person A is not.
Counsel, what if instead of it being 3 bullets, it was 5 bullets? Does it matter?
I don't think it matters because unless there is a sufficient separation in time to make it a separate assault. One of the problems with treating it this way is
what if it's 6, 7? I mean, I know I'm just trying to see how to draw a line here. I mean, I hear what you're saying, but could it be infinite?
Well, I think the line has already been drawn in unit of prosecution cases. In unit of prosecution cases, we look to who the victim is, and we look to whether there's a course of conduct that assaults that victim.
So basically, I hear what you're saying, but basically, the logic of this would be that there's no real distinction between, as it pertains to the number, is what you're saying.
Correct, but a course of conduct can be broken by other circumstances. Had my client fired a shot, went away, came back a half an hour later, fired another
Right,
shot, there could be 2 prosecutions for 2 different assaults, and they could be, and if there was only 1 prosecution, then you could point to the other.
But in the
assault as
same
basis for the score.
transaction, it could be, from your perspective, it could be.
Yeah, the number of gunshots aren't important,
I
just as the number of fists, the punches thrown in a fist fight would not be important.
Mr. Baker, am I correct that the defendant's OV9 was scored to take into account the other 2 victims? And if that is true, is it permissible to still, I mean, it almost, or is it impermissibly sort of double dipping by scoring the presence of those individuals under both OV9 and OV12?
That's absolutely correct, Your Honor. He was scored 9 or 10 points under OV9 under the theory that there was more than 1 victim here. The child and perhaps the woman in the apartment were also counted as victims for purposes of that score. Now, for purposes of that score, the inquiry is a little bit different than whether or not a crime has been directed at those people. If they're in the zone of danger, if they're exposed to the danger, the score is permissible, and that's why we didn't challenge that score. But I do think it helps to support the idea that this was a case in which this was treated as 1 crime, and they were all victims of the same crime, not as separate crimes, one against one person and another against another.
So in some circumstances, it would be permissible to score them both under, or score the factor in the presence of the other 2 potential victims, but not in this case, is that? I mean,
well, I'm conceding that OV9 was properly scored, if that was what the question was about with respect to OV12. Of course, I'm not making that concession, and the idea, again, is that you have to look at the conduct that establishes the sentencing offense only for purposes of the offense for which the defendant is being sentenced, but it doesn't count toward the OV12 score.
okay.
Does that help?
Yes.
Does the court have other questions? Otherwise, I'll reserve the rest of my time for rebuttal.
You may reserve.
Thank you.
Good morning. Amanda Morris-Smith, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan. I urge the court to deny the application and affirm the Court of Appeals because OV12 was properly assessed at 10 points in this case. As you can tell from my brief, I read OV12 as asking whether a defendant committed any contemporaneous crimes, criminal acts within 24 hours of the sentencing offense. It sounds like the court's well familiar with the facts, so I won't belabor them in my opening. But to be clear, the people only charged defendant with assaulting Mr. Sewell, the tenant of the apartment. And after jury trial, defendant was convicted of 2 assaultive felonies for that particular victim. But defendant's actions, firing a gun into an apartment that was occupied by Miss Wilson and her baby, constituted the crimes of assault with intent to do great bodily harm less than murder and felonious assault as against both victims. Although we could have charged defendant with committing those crimes, we did not do so. Under OV12, we can score 10 points, and as I also indicated in my brief, we actually probably could have gone 25 points because it was 3 or more crimes against a person. I know and I readily acknowledge that my reading of OV12 does differ from People versus Light, because the Court of Appeals in that case really emphasized the physical acts or behavior of the defendant. And I did drop a footnote in my brief indicating that I think some of the language in Light is problematic in my view because that language is not contained in the statute. However, if this court liked the language in Light, and I understand why Light reached the result that it did, the people still maintain that OV12 was properly scored at 10 points because we have more than 1 assaultive act. I would waive any remaining free fire time that I have at this time and invite questions.
So why didn't you charge the defendant with the other victims? So you're not in the business of not charging crimes, are you?
That's correct. I can answer that question. I did anticipate it. I'd have to go outside the record in order to do so, if that's acceptable. I did ask the warrant prosecutor specifically why he didn't charge, because it's a valid question. The warrant prosecutor, Chris Coyle, did interview Mr. Sewell on the day that we charged the warrant. From his recollection, again, this was 4 years ago when he did this warrant. He did actually remember it, though. He interviewed Mr. Sewell, and in Chris Coyle's view, the beef in this case was between defendant and Mr. Sewell, and that is how he charged the warrant. The charging prosecutor did not recall the baby coming up in conversation. Due to that fact, we charged 6 counts, 2 assaultive felonies, and then the remaining counts were weapons charges. I did also kind of just puzzles myself why at the preliminary exam, when a different prosecutor is doing the exam, and the testimony comes out about the baby almost being hit by the bullet and Mr. Sewell being panicked that the baby had been hit, why perhaps we didn't seek to add counts and bind it over on additional counts. I did reach out to that prosecutor, but I didn't hear back by this morning. We could have, and I think some courts have acknowledged, looking at this issue, that prosecutors make strategic decisions. Perhaps we would have thought, we were going to focus on Mr. Sewell, the main victim in the apartment that the bullet perhaps was intended for, because there was this earlier confrontation between the 2 men earlier that day. Maybe we thought our proofs weren't going to be good enough to find beyond a reasonable doubt for Ms. Wilson and her baby. I also acknowledge that Ms. Wilson did not appear at trial. I don't think that was deliberate. The trial got moved up very abruptly, and they couldn't secure her presence at court. And that may have been a harder sell to the jury. If we're charging crimes with her as the victim and she's not there to testify, that could have also perhaps been seen as problematic by a trial prosecutor.
Is it the same criminal act, but it has multiple victims? Is that how you want us to think of it?
I look at OV-12 as inquiring as to crimes. So I don't view it as the same criminal act. I think what I heard Brother Counsel kind of perhaps struggling with.
A crime is broken down into sort of its constituent parts, right?
Exactly, elements. I think that's what we need to look at. So in People v. Hardy from 2013, Justice Viviano, your opinion, that was an inquiry. You spent a lot of time looking at OV-7. Well, how do we determine whether the victim in that case was put in a greater fear than necessary to accomplish the crime, or whether the defendant put the victim in greater fear than necessary to accomplish the crime? The offense in that case, I believe, was a carjacking, and the defendant had a shotgun. So he racked the shotgun and then directed it at the victim and demanded, the vehicle. So this court said, well, let's look at the minimum required to establish carjacking, the minimum elements. Well, just having a gun and pointing it at a person and demanding the vehicle, that's carjacking. Racking the gun is one step further. So we can look at that extra behavior beyond what it takes to establish that sentencing offense, to look at that to evaluate OV-7. And then this court went ahead and scored OV-7 at 50 points, or affirmed the scoring at 50 points.
But I think we did that for a particular reason in that case, particular to OV-7, that doesn't really apply here. And I got to get to the language of the case where we did that in Hardy, where my opinion breaks that down. But when I reviewed that in my preparation for this case, and it just didn't seem to, we had to give meaning to language that caused us to figure out what would go beyond sort of the minimum.
Right, to substantially increase the fear, I think, is the terminology
Right.
for OV-7. It's not a perfect comparison, but I think some of the inquiry this court made in Hardy is helpful. I would go back also to McGraw, which I believe is...
We don't typically think of assaultive crimes, as counsel was saying. If somebody gets in a fist fight, your office doesn't ask them how many times were you punched and then charge every single punch as a different crime, do you?
Right, no, and there's actually an ongoing debate in my office about this. I believe, and I'm here to argue, that as a unit prosecution, if there's one fight, multiple punches thrown, that's one assault.
So why isn't this one shooting?
It was charged as, one assault with intent to do great bodily harm and one felonious assault. But for purposes of OV-12, the inquiry is about contemporaneous felonious criminal acts. And I think that is a different inquiry. So again, I'm breaking it down into the elements required to prove the sentencing offense, which is is assault with intent to do great bodily harm, AGBH. What was the minimum required to establish that crime? We had the assault and we had the intent. One bullet establishes those elements. Therefore, the other bullets, if we're going to use the light analysis, establish the felonious acts against Ms. Wilson and her child. And I'm here for any other questions the court may have. I do want to, again, acknowledge that my interpretation of OV 12 really has to come down to the fact that a lot of the terms in that statute are not defined. So felonious criminal act is not defined. Breaking it down under blacks, I believe the inquiry is looking at crimes, and I think that makes sense when you look at OV 13. OV 13 uses nearly identical language, but the period of time that the trial court is asked to look at is 5 years as opposed to 24 hours. So I think that the OVs are meant to take into consideration what happened during basically the entire transaction, though that depends on each OV. Each OV makes a discrete inquiry, but it's trying to give the trial court a big picture. And I think over OV 12, we're trying to figure out whether he could have been charged with additional crimes and he wasn't, and that's what we're going to count for purposes of scoring that variable.
But why does it tell us to focus on the 24 hours after the sentencing offense, the entire 24 hours, if really what the legislature was getting at was how many other crimes were balled up in the same exact transaction or occurrence or criminal, sequence of events?
I'm sorry, why did they pick 24 hours as opposed to?
Well, I mean, I thought you said the legislature wanted us to pick apart the crime in the way that you're doing here.
I think that's what the OVs
I'm asking you, why would they
contemplate.
say 24 hours? Why wouldn't they say a shorter time period? Because we don't think of too many crimes as lasting for 24 hours, do they?
I've had some with crime sprees, starting out as an armed robbery, going to a carjacking, ending in a murder. I did one of those. In this case, the facts are slightly different, but there was this confrontation between Mr. Sewell and defendant earlier in the day. If defendant had brandished a knife at that time and then showed up later with a gun.
Yeah, that would be sort of the classic, what we might think about for
Right.
scoring OV-12, right?
I mean, that would make, I think, the argument perhaps more clear from brother counsel's perspective that we have a completely separate interaction with a, chargeable crime
Well, it would make it
earlier in the
more
day.
clear from my perspective, too.
I guess what is puzzling to me, and I think what I fail to understand the distinction is if we could have charged and gone to trial, if we had charged and gone to trial, and let's say defendant's acquitted because the jury just didn't think that we met our proofs for Mr. Carter assaulting Miss Wilson and the baby. Under
We're dealing with
Golba,
that issue in another case right now, so you could follow closely the
which
opinions
case?
that are forthcoming.
Case from our last case call, but anyway,
Okay.
Yeah.
we digress.
Right.
If
right.
we could have charged and defendant's
There's a debate,
acquitted.
put it that way, it's a debatable, the point you made in your brief is a debatable point, whether acquitted conduct can and should be used to increase somebody's sentence.
Okay, I know under Golba right now, that's the rule that we're following. That's what the trial court and the Court of Appeals would have followed. I mean, it makes sense because it's a preponderance standard. It's not a reasonable doubt standard. So even if the jury didn't think we met our proofs, the trial court, using the entire record evidence before it, including inadmissible evidence like the pre-sentence report, could find under preponderance that the information would be scoreable under one of the OVs.
I think
But
kind of
I'll
a strange
stay tuned.
system, wouldn't it be, if you're tried and acquitted of a charge, but then you're still punished as though you were convicted?
Are you asking questions from a case
Oh,
on the
sorry,
January
did I
case
do
call?
that? All right, I withdraw the question.
I was going to say this court cited in Hardy to a case going back to the Court of Appeals, People versus Gibson. So the scoring of the OVs is not considered punishment in this state. So it's just the guidelines are a tool for the courts to have a reference point, and then they're advisory. Best case scenario, for Mr. Carter, he wins this argument. OV-12 is zeroed out. The case goes back for resentencing. All the OVs and PRV scoring are now back to zero, and we can argue all the scoring elements from the start. It is possible he could have the exact same sentence range as he does now because I conceded OV-4. But if Mr. Sewell showed up for sentencing and gave a victim impact statement and made that record that's necessary, then we could be right back at the same sentencing range. If it does drop down, it does so only by 4 months. So,
Do you think on appeal, the judge is going to let you argue other things that weren't the subject? On remand, the judge will let you argue other things that weren't the subject of the appeal?
My understanding is that if the court vacates a sentence and remands it for resentencing, the entire sentence is, we start anew. We argue everything fresh. So I conceded OV4 because it wasn't in the record. That doesn't mean that we couldn't produce that evidence or, by way of Mr. Sewell's testimony at a resentencing hearing. We could do that. I mean, I think that's
Well,
pretty
if the
easy.
judge permitted you to do that, perhaps you could do that, but, I suppose you could try. I'm not sure if I was the judge, I would listen to that, but maybe a judge would. Okay, thank you.
Okay,
Thank you, counsel.
thank you.
Hardy is a
Do you
case.
agree with that statement she just made?
No. Hardy is a case that helps us, not the prosecution. It helps us because there's statutory language, as Your Honor recognized, that directs the court to figure out what the baseline criminal behavior is.
Yeah, we had to
and then whether
establish a
there's
baseline.
substantial deviation from it. The legislature didn't ask judges to do that with respect to OV12. Instead, the legislature asked judges to look past the sentencing offense, look beyond what the defendant has been convicted and is about to be sentenced for, to other behavior within that 24-hour period for which the defendant has so far eluded any punishment, for which he has not been convicted and won't be convicted. They're apples and oranges. The fact that Hardy says what it says makes sense with respect to OV7. It doesn't make sense.
Hardy
with
was a
respect to
difficult
OV12.
case. We had to sort of construct a framework to give meaning to the words of the statute, and that's what we did there.
Yes.
I think, but I agree with you, the logic and analysis of that case has no parallel here.
And not only has no parallel here, but it just doesn't provide a basis for the same sort of analysis. That's why I'm saying it helps us rather than helps the prosecution. Again, I have to emphasize, a transferred intent theory is not the usual kind of theory when there is a gunshot fired towards victim A and there's a completed crime with victim A. The gunshot misses him, but there's a completed assault. And victim B is not struck. I don't know of any cases in this state or any other state that say that there is a viable case against victim B as well as victim A. The point of transferred intent, again, is to make two halves into a whole rather than to make one whole crime into two. Even if we bought the prosecution's theory that only one of these gunshots counts towards the underlying offense and therefore the other two are available to be scored as separate acts, I should point out that there were 3 conviction offenses here and 3 gunshots, so you could make the argument that the 3 conviction offenses each corresponded to 1 different gunshot, and then there are none left over. So although I don't buy that way of looking at it, I think it answers the prosecution's argument in any event. Does the court have any other questions?
Thank you, Mr. Baker.
Thank you.
The case will be submitted.